Welcome back. So we've talked a bit about the principle of conferral. The principle of conferral means that every binding union act must have a legal foundation in the treaties or in a valid pre-existing parent act. And this provision is known as the legal basis of the Union Act. And the legal basis sets out by law which institutions may adopt the Act, what the Act may do, can it harmonise national law, can it coordinate national law, and so on. And it also sets out the procedure that has to be followed to adopt it. And you'll recall that the ordinary legislative procedure usually applies, but not always. Disputes on whether the Union has exercised its competences tend to take the form of a challenge to the choice of legal basis for a particular act, rather than an allegation that the European Union has no competence whatsoever. So the legal question of what is the correct choice of legal basis is one that has been litigated. And the Court of Justice of the European Union has long accepted that this is a matter of law and not just politics, whether the Union can take a particular legal act on a particular legal basis. So there is law on this established through the decisions of the European Court of Justice on the scope of European Union competence. And we'll touch on some of that law, a few of those cases, in this little lecture. But please note that you will need to find and make notes on more details and more cases in order to be able to do well in a problem question or an essay question in the assessment. In the 1980s and 90s, the Union institutions used a very general power, now found in Article 352 on the Treaty of the Functioning of the European Union. And they used this very general power to adopt law in a range of different areas, like environmental protection and regional policy, where the treaty at that time did not grant any explicit union competence. So Article 352, just to give you an idea, is, as I say, a very general legal basis. And it says, if action by the Union should prove necessary within the framework of the policies defined in the treaties to attain one of the objectives set out in the treaties, and the treaties have not provided the necessary powers, the Council, acting unanimously on a proposal from the Commission and after obtaining the consent of the European Parliament, shall adopt the appropriate measures. So Article 352 has a majority decision making in Council and just an assent from a consent from the European Parliament. So this union legislation, based on this very general legal basis, was part of the critique of competence creep, about how the Union, as Joseph Weiler puts it in a very important article on the transformation of Europe, hyperlink to that article is in the slide, had taken power, the European Union had taken power in such a way as it would become virtually impossible to find an area which could not be brought within the objectives of the treaty. Remember, of course, that when we say the Union took power, we mean the EU institutions, which of course include the Council, which represents the member states, and which, relying on this very general legal basis, has to decide unanimously. And at the time, we often meant that the Union had to agree unanimously to take the relevant measures. Now, in areas like environmental policy and regional policy are subject to the ordinary legislative procedure, if I remember correctly. When the treaties changed the procedure for adopting EU legislation so that qualified majority rather than unanimity in Council became the norm, there was an added incentive for member states who had lost the vote, who had lost the politics, to turn to litigation, so hoping to win the law. And here is a recent illustration, case involving the Czech Republic and a directive called the Firearms Directive. So the European Union has regulated firearms since 1991 as part of its internal market law. And after the terrorist attacks in 2015 in Paris and Copenhagen, the European Commission proposed a tightening of European Union gun laws. And this was met with opposition from the Czech Republic. The Czech approach to firearms regulation is very different to most other EU countries, in part because the Czech Republic has a history of liberal gun possession and a flourishing armaments industry. It's apparently the 7th largest arms exporter in the world. And so the revised directive has consequences for both the Czech economy and its cultural heritage. By the way, how do I know this stuff? I found a journal article on the case, which has all of this background information. You can do exactly the same when you're working on your assessments or getting your notes together. A clash between the centralising tendencies of the internal market and its law and national economic, social or cultural interests is a theme of this module, which we'll return to again and again. So after being outvoted in the European Parliament and in Council, the Czech government turned to a legal action, a challenge before the Court of Justice of the European Union. As a member state, the Czech Republic is a privileged applicant, so it can bring a judicial review claim before the Court of Justice of the European Union under its jurisdiction in Article 263 TFEU. More of that in the electronic workbook. The Czech government's argument was, in effect, that because the revision to the relevant legislation was so restrictive, meant that the relevant legislation became so restrictive, the measure had ceased to be an internal market measure, properly based on Article 114 TFEU, and had become a measure in the fight against terrorism, which would have been properly based on Article 83 TFEU. Again, how do I know this stuff? I googled legal basis European Union competence terrorism, and then I read the relevant treaty provision, Article 83, to check. The Court of Justice of the European Union held that legislation might have several purposes. The predominant purpose is what determines the correct legal basis, and that's established case law for a long time, has been established case law for a long time. Article 114 TFEU can also involve protecting an objective of general interest for the EU, similar to the way that the Court of Justice of the European Union has said that protecting public health can also be a lawful part of internal market legislation in the tobacco litigation. If prevention of terrorist attacks had become the main purpose of the legislation, then Article 114 TFEU would no longer be the appropriate legal basis, and the measure would have been invalidly adopted. But, the court said, an amended directive must be judged by reference to earlier versions. The Court of Justice of the European Union thus held that the European Union legislature had merely adjusted the rules on possession and purchase of firearms to changing circumstances, in particular the terrorist attacks from 2015. This change to circumstances is a core competence of the EU because the EU has to safeguard general interests recognised by the treaty. An earlier case on the Firearms Directive showed that the predominant purpose of the EU's firearms legislation was still free movement of goods, approximation of laws, regulations and administrative provisions of the member states, while circumscribing that freedom with safety guarantees that are suited to the nature of the goods at issue, that is, firearms. And that's case C482, paragraph 2017, paragraph 53. Firearms are inherently dangerous goods, so safety as a general interest recognised by the treaty can be an ancillary purpose of a directive properly adopted on the legal basis of Article 114 TFEU. Now, this is just one case that is important for you to know about and use when you prepare for workshops and complete your assessment in the module. You'll need to look at a textbook, and the textbooks are available in Law Trove, so you can easily see them online. You'll need to look at a textbook and enhance your notes with further cases, and there are some suggestions on the slide. But please note, this is not an exhaustive list. So, to recap, we've covered the principle of conferral, the types of competence, exclusive, shared, internal, external, and we've started to look at some of the specific sources of competence or legal bases in the EU treaty and the legislative procedures associated with each. On the specific legal bases, there's really no substitute to working through the Treaty on the Functioning of the European Union and spotting them. So here's a piece of active learning to help you do that. What I'd like you to do is to work through the quiz on what's on the EU's agenda. The hyperlink for that is on the slide. And as you work through the quiz, for each area that's mentioned, the correct answers and the wrong answers, find the relevant legal basis or competence provisions in the Treaty on the Functioning of the European Union. As I've said, you can use Google or other search engines to help you find the provisions, but check the specific legal text each time in a copy of the TFEU. It's readily available online through Eurelex. If you make a table of your notes, then you'll have a ready reference for when you come to do a problem question in your workshop and in the assessment. And also figure out what the relevant legislative procedure is for each legal basis. So I've done the first one on the slide for you. So this is the first question from the quiz, which you will go to online in a minute when you've finished watching this little lecture. And so this talks about several different areas of potential EU legislation in these three options. And here is what I have done in terms of some notes. So economic growth and job creation is found in Article 121 TFEU, which involves coordination of the economic policy through a process involving information sharing, guidelines, conclusions, recommendations, and monitoring. It's known as multilateral surveillance. Employment policy is found in Article 145 TFEU. Thank you, Corrie. That's very helpful. This is my cat. Article 145 TFEU, member states shall work towards developing a more coordinated strategy for employment, and Article 147 TFEU gives the EU competence to encourage cooperation between member states, support national action, respecting national competences. The process is set out in Article 148 TFEU. It's similar to the economic policy coordination process, which is in Article 121. Article 149 TFEU gives competence to adopt incentive measures using the ordinary legislative procedures, and there is an explicit exclusion of harmonisation of national law. Article 153(2) subparagraph B TFEU gives competence to adopt employment laws in the list in Article 151, which is things like health and safety at work, working conditions, equality between men and women at work, by directives only, not by regulations, only minimum harmonisation using the ordinary legislative procedure, except for social security and social protection of workers where their employment contract is terminated, collective labour law, unemployment conditions for non-EU citizens legally resident in the EU, where the Council acts unanimously and Parliament is only consulted. And this is one of the exceptions to the general rule that the ordinary legislative process is used to adopt directives. Energy policy is found in Article 194(2) TFEU without prejudice to other provisions of the treaties. So you need to think about other overlapping measures like environmental competences or internal market where that might overlap. The ordinary legislative procedure is used for securing energy supply in the EU. Environmental policy is found in Article 192 TFEU. I'm laughing because my cat keeps pushing the laptop and moving the camera. Environmental policy is found in Article 192 TFEU, involving the ordinary legislative procedure, again to achieve the objectives in Article 191 TFEU, which include protecting the environment, prudent use of natural resources. Article 192(2) TFEU sets out the special legislative procedure for fiscal measures affecting town and country planning, water resources, land use, except waste management. So as I say, there really is no substitute, is there, Cordelia? There really is no substitute between for just going through the treaty, the text of the treaty, and finding the legal bases and looking at the legal text, because that is what you're going to have to look at when you're completing a problem question, either in your workshops or in the eventual assessment. I'll see you again in the next video.